In addition to issues relating to intimate details of marriage, family, and sexuality, substantive due process also has been applied to issues concerning the end of life. One of the first cases to consider whether there is a right to die was the Cruzan case in 1990. Nancy Cruzan was in an auto accident that left her in a persistent vegetative state. In such a condition, the patient's body can continue to function without artificial ventilation or respiration, and the patient exhibits some motor reflexes, but there's no evidence of higher brain functions. Food and water must be provided artificially because the patient is not capable of eating and drinking. Cruzan did not have an advance directive, that is, a set of instructions for how or whether her life should be sustained in the event of illness or accident. Her parents petitioned for an order requiring the removal of artificial nutrition and hydration. The trial court granted the order, but the Missouri Supreme Court reversed and held that artificial nutrition and hydration cannot be removed absent clear and convincing evidence of the patient's intent. On a petition for certiorari from the Missouri Supreme Court's decision, the U.S. Supreme Court affirmed. In the opinion for the majority, Justice Rehnquist stated that a competent person has a constitutionally protected liberty interest in refusing unwanted medical treatment, and that this can include refusing life-saving nutrition and hydration. At the same time, he noted the state has an interest in preserving human life and preventing abuse, such that the state can include the procedural safeguard that a surrogate must establish the patient's wishes by clear and convincing evidence. Justice Brennan dissented, joined by Justices Marshall and Blackmun. According to Justice Brennan, there's a fundamental right to die with dignity, and the state has no legitimate interest in someone's life completely abstracted from the interests of the person living that life that could outweigh the person's choice to avoid medical treatment. After the U.S. Supreme Court's decision, the state of Missouri withdrew from the case, and Nancy Cruzan's parents satisfied the clear and convincing evidence standard before the trial court. Nancy Cruzan's feeding tube was removed on December 14, 1990, and her body ceased functioning on December 26, 1990. The question of whether a terminally ill person has a right to physician-assisted death and whether it is ethical for a physician to provide such assistance has been debated since antiquity. Although the practice historically has been prohibited in many Western countries, it often was secretly practiced and tolerated. The issue reached a fever pitch in the United States in the 1990s, however, when Dr. Jack Kevorkian, a pathologist, publicly flaunted his role in over 150 assisted patient deaths. Kevorkian evaded criminal culpability for some time, but eventually was convicted and served over 8 years in prison in Michigan. Some palliative care activists began to press for a legal right to physician-assisted death, while some states began to enforce existing laws, and activists on the other side of the issue, including some anti-abortion groups, began to press for stricter laws against physician-assisted suicide. In Glucksberg, the court upheld a Washington state statute that prohibited assisted suicide by anyone, including a physician, against a substantive due process challenge. Although the judgment upholding the Washington law was unanimous, only parts of Justice Rehnquist's opinion for the court attracted a majority, and some of the concurrences expressed different views about the substantive due process analysis. According to Justice Rehnquist, the broad language in Casey suggesting that many of the rights and liberties protected by the Due Process Clause sound in personal autonomy does not warrant the sweeping conclusion that any and all important, intimate, and personal decisions are so protected. The right to assisted suicide, he said, is not fundamental, which means a state law restricting assisted suicide is subject only to rational basis review. Here, he concluded, the Washington statute had a rational basis relating to the state interest in preserving life. Justice O'Connor wrote a concurrence joined by Justices Ginsburg and Breyer. According to Justice O'Connor, although the Washington statute was facially valid, the result could be different under an as-applied challenge by a mentally competent person who is experiencing great suffering. Justices Stevens, Souter, and Breyer also added their own concurrences. According to Justice Stevens, the right to control timing and manner of death is a dignity interest that is broader and more basic than the common law, and in an as-applied challenge, the state's legitimate interest in preventing abuse does not apply to an individual who is not victimized by abuse, who is not suffering from depression, and who makes a rational and voluntary decision to seek assistance in dying. According to Justice Souter, the unenumerated rights in the Constitution begin with a concept of ordered liberty, comprising a continuum of rights to be free from arbitrary impositions and purposeless restraints. Justice Souter acknowledged that fundamental rights are rooted in tradition, but stated that the tradition is a living thing. Although the state's interest in preventing abuse is serious enough to warrant legal restrictions, Justice Souter said, whether allowing regulated assisted suicide with teeth is good policy is up to the legislature. For Justice Breyer, the issue was not whether the Constitution provides a right to commit suicide with another's assistance, but rather whether it includes a right to die with dignity. In particular, he said, a person's desire to avoid severe physical pain should be considered in any as-applied challenge. Vacco v. Quill, also decided in 1997, was a companion case to Glucksberg. While Glucksberg was a facial challenge to an assisted suicide ban under substantive due process, Quill was a facial challenge to a New York statute under the Equal Protection Clause. The Equal Protection Challenge was based on the fact that, while New York prohibited assisted suicide, at the same time state law allowed patients a right to refuse life-saving medical treatment. In an opinion for a unanimous court, also authored by Justice Rehnquist, the court held that the New York facial Equal Protection Challenge also failed. According to the court, there's a rational basis for distinguishing between allowing someone to die of a disease and causing death by administering a drug. The right to refuse treatment, the court said, is grounded in traditional rights to bodily integrity and freedom from unwanted touching, while the ban on physicians administering life-ending drugs is grounded in protection of medical ethics, preventing euthanasia, protecting disabled and terminally ill patients, and preservation of human life. As noted in our discussion of the Cruzan case, the medical, philosophical, ethical, and legal issues surrounding end-of-life decisions remain subject to robust debate in the United States and around the world. Since the court has not broadly recognized a general right to assisted suicide under either substantive due process or equal protection, and Congress has not acted on the issue, the locus of debate in recent years has mostly been in state legislatures and state courts. Presently, only a few states permit medical aid in dying, while every state has law that permits some form of advance directive for the termination of life-sustaining treatment, and the Federal Patient Self-Determination Act of 1990 requires healthcare facilities, but not individual physicians, to notify patients of their right to refuse treatment under applicable state law.